One of our favorite secret weapons for problem solving and negotiating is local real estate attorney Brian Lytle. In this series of Get Smart, Brian shares insights on heirs.
Hi, I'm attorney Brian Lytle, and in today's Get Smart segment, we're going to take a look at heirs as sellers. Before we get to that topic, I want to remind you that this is not specific legal advice. It's a broad overview. And in the Lismore geographic area, there are 3 contracts. There's a RAIN contract used on the Virginia Peninsula, the CVR contract that's used in the Richmond area, and the Virginia Realtor contract that's used in the Williamsburg area and really across the state. Each of those contracts handles things a bit differently here and there, and in some cases significantly so. But in our topic today, heirs, there really is no difference. In any event, all are fairly drafted for both buyers and sellers, and in that way, your Lismore and Associates real estate agent can use the same contract whether he or she represents you as a buyer or represents you as a seller. Again, the specific purpose of this Get Smart segment is to take a look at heirs as sellers. And if you have any questions or need more resources, please ask your Lismore and Associate agent. So again, what we're looking at are transfers at death. That is, an owner of property has died, and now we're trying to determine who the seller is or sellers are. And in the Get Smart estate segment, we identified that there are 4 basic ways that can happen: survivorship in a deed and a transfer on death deed, and both of those transfer title to the named parties, and that's usually pretty straightforward. You just take a look at the deed, and that's who your owners and sellers are. We also noted if those 2 don't apply, then one dies testate, that is with a will, or intestate without a will. And those are the 2 broad categories. So this segment is concerning the situation where an owner of the real estate has died intestate, that is without a will. Now, I'd like to note here that where there's a will, one qualifies as an executor. Where there is no will, one qualifies as an administrator of the estate. Whether there's an administrator or not is irrelevant for the purposes of selling real estate, because administrators have no power whatsoever to sell real estate. They can get it if they file a lawsuit to get it and the court grants it, but absent that, there is an administrator of an estate has no power to sell real estate. So who does inherit the real estate? Well, if somebody dies in Virginia, if someone dies without a will, then the Virginia General Assembly has written a will for that person. And the basic scheme of the Virginia General Assembly's will, that is dying without one, is essentially this. First, so there's a list of priority. And first on the list is the property goes to the spouse. But there's a little complicated caveat to that. That is if the decedent has children that are not also the children of the surviving spouse, then it's divided 1/3 to the surviving spouse and 2/3 to the surviving children of the decedent. And if you think about it, that makes sense, so that in second or third marriages, the decedent's children aren't being disinherited. But essentially, it's spouse unless it's complicated by surviving children. If there's no spouse, then it goes to the children. If there are no children, it goes to parents. If there are no parents, it goes to siblings, and so on and so forth. And it will simply work its way down until the law finds someone that is related by blood, essentially, to the person who died. So how do you figure that out, and how do you make it official? Well, an attorney really needs to review that on a case-by-case basis, taking a look at the family tree, that is, who survived, and then you make it quote-unquote official by preparing and recording what's known as a list of heirs. The list of heirs is a formal legal document prepared in a particular format, signed by someone with knowledge under oath that gets recorded in the land records, and that is going to vest title in the listed heirs. If that's all approved, then the sellers are the names of the persons who inherited the real estate. Now, let me go back just a second, because even when someone dies with a will and the will is probated, a list of heirs is also recorded with the will. But that list of heirs does not control who inherits the real estate. The will does. In the context we're talking about, remember, there is no will. That is, the person has died intestate. So we're determining who the heirs are under Virginia law. Once that's done, the list of heirs is recorded, and then those individuals identified as having inherited are the sellers of the property. They will sign the listing agreement, they will sign the contract, they'll sign the deed. And it may well be that those sellers have different interest. If the property is going to siblings, for example, and one of the siblings predeceased the decedent but had children, then the property may go 1/4 to a brother, 1/4 to a sister, 1/4 to a brother, and then 1/8 to the two children of the sibling who predeceased the decedent. So I know that sounds complicated, and it is. That's why you need to get your Liz Moore and Associates agent and an attorney involved very early. You don't want to be working through this 2 days before closing, and so that's why you never want to just say the seller is the estate of, in this, let's say, Brian Lytle. That's just wrong. That means, number one, it's not a formal entity, but that always signals to me and many settlement agents that no one has really figured out who the sellers are. So don't do that. Again, if you have any questions, reach out to your Liz Moore and Associates agent. He or she can direct you in the right way. And again, whether it's me or somebody else, I would strongly recommend you get an attorney involved early on in that process. Thanks, and have a great day.
Be sure to subscribe and turn on notifications for our next installment of Get Smart with Brian Lytle.